The judiciary pronounces itself under common law, and that is the use of the case law and also the judicial opinions, court orders, and decisions court makes from time to time and in any court station as founded. But we are going to look at this from hierarchical manner. The hierarchy of our judicial system begins with the Supreme Court. The Supreme Court of Kenya is the highest court on the land, and it is headed by the Chief Justice, who is the head of the judiciary and the president of the Supreme Court. Those are the supreme courts or the superior courts in the level or in the hierarchy. That means the topmost, at the top apex of the triangle, we find the Supreme Court jurisdiction. Then followed by the Court of Appeal jurisdiction. Then we have the High Court jurisdiction. The High Court is the bulkiest, and it has many judges and a lot of cases to handle at the same time. It is the court of what we call original jurisdiction, because this is the trial court. This is where litigations begin and disputes. This is where people take their matters and disputes in terms of civil disputes, civil offenses, and petitions. And also this is where we handle criminal offenses in which the prosecutor takes the defendant or the suspect for due process, and that is the trial process. So in this case, so the courts are classified in a hierarchical form in which we have superior courts, starting with the Supreme Court and followed by the Court of Appeal and the High Court. High Court, I told you, is wider, has got wider jurisdiction and wider competence when it comes to adjudication issues, whereas the Court of Appeal is limited to the appeal matters, that is the judicial review and the review of judgments, as well as other matters related to the appeal. The Supreme Court also has got very limited jurisdiction because it cannot handle all matters.
I have a question.
Please, yeah, come on.
Thank you. This is a court.
A court, yes.
So my question goes back to the sources of law.
That's right, Chakov, carry on.
I seek to know what is the difference between international law and the general and international general rules.
Oh, very good. Well, when we talk of the international law, we look at it from what I would call the substantive international law and what I would call the customary international law. So when we talk of the substantive international law, we are making reference to the treaties. Those are statutes, or maybe you can call them conventions, that countries have adopted through putting their signatures or appending their signatures and ratification. So that is substantive. But customarily, in the international law, there are certain principles that we consider general rules of the international law. For instance, the human rights principles, such as the right to life, those are already considered general rules of the international law, or we call them the norms or the jus cogens. So jus cogens are those general rules of international law that have been taken as international principles, of which no state can make any legislation to go around them. That's why they are known as uh, overarching norms at the international level. There are many, but it is good to understand them, especially in the context of the universal human rights rules. So the universal human rights rules, such as the right to life, the fundamental freedoms of people, there are many. And in that case, there are rules that we now consider under Article 2 of the Constitution, sub-Article 5 as the general rules of international law are law in Kenya. That means whatever is considered to be general rule in the international law, as I've mentioned, the right to life, will be considered law in Kenya. This may again interfere with some understandings and contextualization. Let's talk about death penalty. For instance, death penalty is still law in Kenya because it has not yet been repealed, even though Kenya is not practicing it. I think it was since the time of President Moi during the coup attempt that some individuals were hanged. And from that time, Kenya has not hanged anyone as per our records. And in that case, we see Kenya respecting the general rules of international law by slowly moving towards the abolition of death penalty. So it is a question of seeing how our country and our government is reacting to those general rules of international law. I wonder if I've made myself understood.
You did, sir.
Okay, thanks so much, Mr. Kopp. Somebody else?
Question?
Okay, come.
Yes. Is it in order to consider agreement, formal agreements, a source of private laws?
Yes, of course, you are right. This goes hand in hand with the definition of the contract. Contract is all agreements that are enforceable by the law. So every agreement, as long as it can be enforceable, is a contract. So in this manner, again, we want to believe that not all agreements are contracts and not all agreements are good. Let's say that you make agreement with someone to trade in prohibited or banned drugs or narcotics or maybe cocaine. Well, you agree and you want to do it and you have done it successfully, but it is not law because it is illegal. So the fact that it is illegal, it is an agreement that is not considered enforceable, at least in the Republic of Kenya. So looking at law from this context is enabling us to understand that not all agreements we do make can be considered contracts and can be enforceable. So the enforceability of the agreement is what makes that agreement a contract. And
I have another question.
Yeah, please, yeah.
Yes, this is a court again. My question is, in terms of the role of courts as the source of law, I ask, do the courts pronounce rules which interpret laws, or do the courts create laws?
Good. Okay, that is good because I said it earlier under the source of law in Kenya, and we agreed that the judiciary manifests its power through the common law regime. And in that case, the common law is about court decisions. It is the interpretation is part of the court decisions, and that one is part of the common law. and it is law. So that is why we say it is judge-made law, because the judge makes the law at that material time. But we are talking about the judges, we are talking about the courts of record, not the magistrate courts. Let us get it right. The decision made by the court is legally binding upon the court itself. That means the judges always bind themselves by precedents, and that is under the principle of stare decisis. So stare decisis, that means, simply translated in English, that we stand by the decision. So judges support their decision or stand by their decision. So let's say that Honorable Justice J.B. Ojwang had made a ruling that became precedent. Even at his departure as a retired judge, any judge making the law on the same matter will have to bind himself or herself with the ruling. That is what we call the judge-made law, or the precedent, or the common law, or the case law. So when you hear of such terms, please, they mean one and the same thing. Now, when judges order the subordinate courts through writs, like habeas corpus, such as certiorari, or any other order that they make, even mandamus, those orders are considered binding. So the court can make order even to the executive, like the question of Miguna versus the Republic. We find that the court made several orders or issued such orders. That doesn't mean that those orders are no law. They are law and they are binding. So the disobedience to such orders are punished through court contempt. Court contempt is an offense against the judiciary, against the court. It is an abuse of the court power or court authority, and that is also punished by the law in Kenya. Well, whether the court will punish the administrators that disobeyed it, that is a subject of another sitting. But for our understanding, it just suffices to acknowledge that judges make the law in every common law system, whether in the United Kingdom or in the United States of America or elsewhere in Africa, where the English common law has been adopted and is being put in practice. Have I answered your question, Mr. Koth?
Yes, my question is,
Yep.
the recent advisory by the Chief Justice Maraga.
That's right.
On the dissolution of the parliament.
Yes.
Does it constitute a common law?
Well, you know, that is the letter known as advisory letter, which under the Constitution, Article 261 or sub-Article 7, the Chief Justice is just exercising his constitutional power. The Constitution gives the Chief Justice this power to advise the President to dissolve Parliament. And it says, upon the receipt of the letter, the President shall dissolve Parliament. How and for within what time, the Constitution does not explain all these details. But does it become precedent? Of course it does. That means the same document or the same advisory letter can be replicated in future. That's what it means. I give you example of the rulings made by Justice Gungi Mumbi when she became very clear in her statement when it comes to issues of corruption involving a sitting governor. And she said a sitting governor that is undergoing investigations on financial crimes and corruption should not access the office. And it was applied on former governor of Kiambu, Honorable Waititu, and it worked. And it is being applied even to Honorable Sonko in Nairobi. So this is the court order, which of course the advisory letter from the Chief Justice must also enjoy. So it is also part of the precedent. Thank you for asking that question because it is.
All right. Number one, I didn't get proper time to look at the judicial review. I've just looked at it this morning. And of course, then I have a few things that I have noted. Number one, Audrey. It was Andrew Mbugua. And we are seeing him at that time petitioning the courts to help him at that time change from a him to a her. And of course, from the onset, it appeared NEC through their executive officer had agreed that they would go ahead and help him change his name to her name or whatever she wanted. And
That's
it was
right.
until he asked them to tell her the procedure of how to go about changing her name from Andrew to Audrey, that another email surfaced and they seemed to disown the earlier communications, saying that NEC does not get information from, NEC gets information from the school, or rather the examination centers, on the particular gender of a person, and so it is not up to them at this point to tell whether this person was a girl or a boy, so they are not to blame if they had said he was a boy by then, and therefore their stand at that time was that they were not going to help him change her gender. Of course, there were some requirements that he was told that in case he gave them in, probably NEC might consider changing her name. But at this point, you realize that is not what they are saying. At this point, they are saying we don't do this. That once we have issued one certificate to a person, we don't go ahead issuing another. And this is now what made Andrew to go to court to seek the court's help in the same. And Honorable Korir, we are seeing, is the one who handled this matter. He listened to the parties, and at the end of the day, he decided that Andrew had a right, that Andrew needed to be allowed to change his name to Audrey, and that there was nothing that was going to affect her certificate, and also other certificates for other people were not going to be affected in any way. So the court's opinion was that there was no harm in NEC changing its certificate, the certificate for this particular person, to whatever she wanted. Of course, the evidence and medical examinations and all those were produced to show that Audrey indeed had gone that transformation, and now she was a girl. And so, yeah, the courts allowed her plea was allowed, and she's now Audrey.